On the record, 9:15. Aloha, mai kako. Good morning, everyone. This is the February 8th, 2023 Land Use Commission meeting. This is an in-person meeting, which is being held at the Maui Arts and Cultural Center, Haynes Meeting Room number 1, Cameron Way, Kahului, Hawaii 96732. This meeting is open to the public. Court reporting transcriptions are being done from the Zoom meeting, so we've got a parallel process where we are recording the meeting on Zoom, and we have some people attending the meeting by Zoom from Honolulu. For all meeting participants, I would like to stress the importance of speaking slowly, clearly, and directly into your microphone. I might say loudly too. Before speaking, please state your name and identify yourself for the record. Even though this is an in-person meeting, please be aware that all meeting participants are being recorded on a digital record of this Zoom meeting for court reporting purposes. Your continued participation is your implied consent to be part of the public record of this event. If you do not wish to be part of the public record, you should exit the meeting now. I will share with all of you that we will take breaks from time to time, and there will be a lunch break at 11:30 if we're still in session. The breaks from time to time will be approximately every hour for nominally 5 to 10 minutes. My name is Dan Giovanni, and I have the pleasure to serve as the LUC chair. We currently have 8 seated commissioners. Along with me are Commissioners Nancy Cabral and Lee Ohigashi, Gary Okuda, Wiki Kamakea Ohelo, George Atta, Mel Kahale. Commissioner Michael Yamani is excused from this meeting. Also attending, by Zoom is the LUC Executive Officer, Daniel Orendenker. Here with us today is the LUC Chief Planner, Scott Derrickson, LUC Staff Planner, Martina Segura, LUC Chief Clerk, Ariana Kwan, and attending by Zoom, LUC Attorney General, Dan Morris. Again, court reporting transcripts are being done from this Zoom recording. Our first order of business is the adoption of the minutes from the meeting of December 7th, 2022. Ms. Kwan, has there been any written testimony submitted on the December 7th minutes?
No, Chair.
Thank you. Are there any members of the public, Ms. Kwan, who have signed up to testify on the adoption of the minutes?
Not at this time, Chair.
Thank you. Commissioners, are there any corrections or comments on the minutes? If not, is there a motion to adopt the minutes for December 7th?
So moved.
Second.
Moved by Commissioner Ohigashi and seconded by Commissioner Cabral. All in favor of the adoption of the minutes, please say aye.
Aye.
Anybody opposed? The minutes from December 7th, 2022 are adopted. Thank you. The next agenda item is the tentative meeting schedule. Mr. Orendenker, can you share that with us, please?
Thank you, Chair. Can you hear me okay?
We hear you good.
Oh, great. Thank you.
Oh, well.
Tomorrow, we will be meeting on Maui for the DOE Kehe High School status report. On February 22nd and 23rd, the calendar is open. Our next scheduled meeting is in April 13th. We have WIO Limited Partnership. And we have tentatively on April 26th, the Waimanalo Gulch matter. We would caution the commissioners not to plan to release the remaining dates until they've heard from us. We have a number of items that we understand may be filed on short notice. Thank you.
Thank you, Mr. Orendaker. Commissioners, do you have any questions on the calendar as presented? Hearing none, thank you. Our fourth order of business is the authorization for LUC conference travel. There's a national planning conference April 1st through April 4th, 2023 in Philadelphia, Pennsylvania. And the Urban Land Institute Conference, May 16 to May 18th, 2023 in Toronto, Ontario, Canada. Mr. Orendaker, could you please explain the travel plans and for these to be authorized by the commission?
Thank you, Chair. As the commission is in actuality the governing authority on the Land Use Commission budget, we have scheduled or would like authorization to send 3 staff and 2 commissioners to the APA conference in Philadelphia. And we would like to get authorization to send 2 staff and 2 commissioners to the ULI conference on May 16th to the 18th. The budget is sufficient to handle those items. And we're just merely seeking confirmed authorization to undertake the travel.
Thank you, Mr. Orendaker. Commissioners, what is your pleasure?
Sure.
Wait a minute, Ms. Cabral?
I move to approve that expenditure and take that action. Thank you.
Second. Okay, so the authorization for the travel, I'm just going to repeat it, what I heard, for the National Planning Conference would be 3 staff plus 2 commissioners, and for the Urban Land Institute Conference in Toronto would be 2 staff plus 2 commissioners. And we do have sufficient budget, and we have been moved and seconded for this commission to authorize that travel from our budget. Is that correct?
That's correct, Chair.
Correct. Yes.
Okay, so commissioners, what's your pleasure? Can I have Mr. Orendaker please poll the commissioners on the motion?
Chair, I think this can be done with just a voice vote.
Okay, all in favor, say aye.
Aye.
Any opposed? So moved. Our fifth order of business is the closing argument and decision-making on A19-809 PÖLAMA LANA, MIKI Basin, Maui. It's a petition to amend the land use district boundaries from agricultural district to urban district for an industrial park and other uses at MIKI Basin. Approximately 200 acres of lands situated in Lanai City. Let me briefly describe our procedure for this agenda item. First, I will ask if there are any disclosures from the commissioners. Then I will update the record and I also ask the parties to identify themselves. Then I will recognize the written public testimony that has been submitted in this matter, identifying the person or organization who has submitted the testimony. Next, I will call on members of the public who wish to testify on this district boundary amendment for A19-809 PÖLAMA LANA. Members of the public will each have 2 minutes to provide their testimony and should stand by after their testimony to respond to any questions by the parties or the commissioners. When all questions have been completed, the chair will excuse the witness and call the next witness to the witness box. After completion of the public testimony portion of the proceedings, I will give each of the parties an opportunity to present their closing arguments. After the parties have completed their closing arguments, I will again allow public testimony. After that portion of the proceedings, the commission will enter into formal deliberations. Disclosures. Do any of the commissioners have any disclosures to make regarding their participation in this agenda item? Commissioner Okuda.
This is Gary Okuda, Mr. Chair. I have the following disclosure to make, which occurred since the last hearing. I represent the ILWU Local 142 in a case titled International Longshore and Warehouse Union Local 142 Plaintiff versus Kauai Island Tours Incorporated Defendant. It's a case pending in the Fifth Circuit Court, case number 5CCV-20-035. The defendant has an attorney that entered an appearance, Mr. Mauna, M-A-U-N-A, K-E-A, Trask, T-R-A-S-K, who represents the defendant. And so I'd like to make the disclosure that Mr. Trask, who's from the Cade Schutte firm, represents the defendant in a case where I represent the plaintiff, ILWU Local 142. My representation of the union will not affect my viewpoints or decision-making in this case. And except for the fact that I'm the attorney representing the ILWU Local 142, I do not have any financial interest in the outcome of the case. Thank you.
So I'm going to do something a little different. I'd like the parties to identify themselves for the record, and then I'll ask each of you if you have any objection to Mr. Okuda continuing.
Very good, Chair. Cal Chipchase for the petitioner. With me in person is Kiki Puadancel as the representative of PÖLAMA Lanai. Online, appearing online today, are Chris Gooden, Stacy Gray, and Molly Olds.
Thank you, Mr. Chipchase. County of Maui.
Thank you, Mr. Chair, and good morning, members of the commission. I'm Michael Hopper, Deputy Corporation Counsel with the County of Maui, representing the Maui County Department of Planning. With me are Acting Planning Director Kathleen Aoki and Planner Kurt Wollenhaupt.
Thank you, Mr. Hopper. OPSD.
Good morning, Deputy Attorney General Brian Yee on behalf of the Office of Planning and Sustainable Development. With me is Aaron Sadagawa and Katya Balaciano from the Office of Planning and Sustainable Development.
Very good. Mr. Chipchase, do you have any objection to the continued participation of Commissioner Okuda based on his disclosure?
No objection, and I'll add, just so the record is complete, that I have no involvement in that case and was not aware of it until this morning.
Thank you. Mr. Hopper from the County of Maui.
No objection, Chair.
Thank you. Mr. Yee.
No objection.
Thank you. Anybody else, any other commissioners want to make a disclosure? So I have a disclosure to make of my own. I've made it previously on this hearing. Ms. Kiki Puadancel and I are former colleagues at the Hawaiian Electric Company. We worked together several years ago, and we don't have any business ongoing at this current time. I have no financial interest whatsoever in the matters involving PÖLAMA Lanai. So I think that I could proceed on a fair and unbiased basis and ask you if you have any issues with that, petitioner.
Chair, Cal Chipchase for petitioner, no objections.
Thank you, Mr. Hopper.
No objections, Chair.
Mr. Yee.
No objections.
Thank you. Last call for disclosures. Seeing none. Let me update the record. The commission last heard this matter on November 16th, 2022, and since then, the Land Use Commission updated the deadline dates in collaboration with the parties. On December 20th, 2022, the LUC received the petitioner's stipulation regarding deadlines. On January 3rd, 2023, the petitioner filed proposed findings of fact, conclusions of law, and decision in order. On January 9th, 2023, the LUC received petitioner's amended proposed findings of fact, conclusions of law, and decisions in order. On January 18th, 2023, the Office of Planning and Sustainable Development filed their response to the amended proposed decision in order. On January 18th, 2023, the LUC received the petitioner's stipulated Second Amendment proposed findings of fact, conclusions of law, and decision and order. And on January 26th, 2023, the LUC mailed and emailed an agenda for February 8th to 9th, meeting to parties statewide in the Maui list. So parties have already identified themselves for the record. So I thank you for that. So I'll now recognize public testimony. Ms. Kwan, has there been any written testimony on this matter?
No, Mr. Chair.
Thank you. Now I will now call on any members of the public to provide testimony on this agenda item. Are there any members of the public present who would like to testify in person? Seeing none. I will say that the public testimony has been concluded for now, but later I will give a second opportunity if anybody wishes to provide public testimony. It's now time for closing arguments. Mr. Chip Chase, do you have any comments you would like to make at this time?
Yes, Chair, if I may, we have a brief slide presentation. My goal in this, Commissioners, is simply to remind everyone of the evidence. The hearing was not that long ago, so I won't belabor it. To cover the conditions, in particular the conditions that have been stipulated among the parties, and then of course to be available to answer any questions the Commission may have. I estimate 15 minutes at the most.
Please proceed.
Thank you, Chair. Commissioners, as we presented the evidence the last time that we met, this district boundary amendment would not only meet the community plan goal of providing additional industrial space for Lanai, but has already been designated for a renewable energy project, the consolidation of existing industrial uses elsewhere in the island, and to make land available for light and heavy industrial needs as they arise throughout the island. The stipulated order, as the chair read, went through various iterations. We have reached agreement with both the county and OPSD on the form of the order, including all conditions, including the conditions that we discussed at the end of the hearing with the chair and with former Commissioner Chang related to the representations and other commitments that Pūlama Lanai is prepared to make. I'll cover those at the very end of this closing argument. What I want to turn to now is the standard for approval of the district boundary amendment. The evidentiary standard is more likely than not a preponderance of the evidence. The considerations that this commission looks at for approval are whether the project is reasonable, not violative of HRS section 205-2, and consistent with the policies and criteria established pursuant to 3 specific statutes. Those are Section 205-16, which requires conformance with the state plan, 205A-2, which is the Coastal Zone Management Act, and 205-17, which lists the commission's decision-making criteria. We'll discuss each of those very briefly in turn. The first requirement is that the district boundary amendment, the DBA, is reasonable. Here we've shown that the industrial park provides for consolidation of industrial uses, is adjacent to existing industrial uses, and is located both far enough from the city so as not to impact surrounding land uses, but also be conveniently located so that folks can access the industrial area. Under those facts, we believe that the petition, the district boundary amendment, is reasonable. Turning to section 205-2, it provides in part, quote, urban districts shall include activities or uses as provided by ordinances or regulations of the county within which the urban district is situated. As I mentioned at the beginning, this district boundary amendment would align the land uses on Lanai with the community plan, which went through extensive public review and comment. And in addition, there is a pending application for a change in zoning that would move the land from agriculture and interim zoning districts into light industrial and heavy industrial, both aligning with the community plan and, if granted, this district boundary amendment. The third requirement has those 3 subparts that I mentioned. And as to those, the petition details how it conforms to the Hawaii State Plan on pages 37 to 43. With respect to the Coastal Zone Management Act, this project is located more than 3 miles from the coast, which means the principal area of concern would be surface water runoff generated or impacted by the project. As set forth on pages 16 and 17 of the petition, the project was designed to contain runoff in the basins with sufficient capacity so as not to discharge runoff into the ocean. That takes us to section 205-17. We've put that section up on the screen in incredibly tiny font. I will briefly cover the different parts of it. As to the first factor, as detailed on pages 37 through 43, the industrial park conforms to the applicable goals and policies of the Hawaii State Plan and the adopted functional plans. And on those pages, we identify the goal or the policy and the way in which that conforms. And that's consistent with the evidence that was presented. As to the second factor, the petition conforms to the standards for determining urban district boundaries, and we've detailed that on pages 47 through 50 of the petition. The third factor considers the impact of the proposed reclassification on 6 areas of state concern. To briefly run through those. As to Area A, the project will not impact natural habitats. The site was a former pineapple field, and it will preserve natural coastal systems by preventing runoff as described in the petition. As to Area of Concern B, the project assessed the cultural and historical impacts, and you heard from our witnesses at the last hearing, and worked with SHPD to ensure compliance with all state requirements. The project is also mitigating impact to flora fauna, such as seabirds, and as I'll discuss, any potential impact to hoary bats. In addition, protective measures were implemented to prevent invasive species from being introduced as part of the project or the project development. Turning to Area C, the industrial park will benefit Hawaii's economy, and there will remain ample agricultural land for cultivation on Lanai. And at our last hearing, we discussed the relative available acreages and the benefits both in the development and operation of this project. As to Area D, no state funds are required for this project. It is entirely privately funded. The commitment of water will occur as detailed in the petition and at our hearing, but we will develop additional source, and there is adequate supply to meet the needs of the industrial park through all its development phases. As to Area E, during construction, more than $78 million will go to trades, creating short and long-term employment opportunities. And by 2030, we are estimated to generate $670 million in state taxes and nearly $380 million in county taxes. Area F of the state concerns, the final area, relates to housing. This project doesn't concern Area F because it's not a housing project. The fifth factor is the compliance with or conformity with the county general plan. We've detailed our conformance to that plan on pages 45 through 47 of the petition. The sixth factor are the representations and the commitments made by PÖLAMA Lanai in its writings and throughout the course of this hearing. Those representations and commitments are included in the stipulated conditions. If I turn to the conformance with HAR 15-15-78 and 79, these are the remaining 2 decision-making criteria. The project will be more than 87% complete within 10 years of the commission's approval, sort of the minimum given the way the project is structured. The remaining 26 acres may be developed within that period as well, as uses and needs arise, or it may take more than 10 years to completely fill that 26 acres. But we anticipate that it would not take more than an additional 10 years before even that portion of the project has been completed. The last thing that I wanted to cover are the stipulated conditions. We put those up on the screen, and of course they're detailed in the stipulated findings, conclusions, and decision in order. To summarize them, condition 1 relates to preserving water resources and requires consultation with the Commission on Water Resource Management, installing water efficient fixtures and water efficient practices wherever practicable. Condition 2 relates to stormwater management, requiring the implementation of best management practices in preventing pollution and runoff during storm events. Condition 3 relates to participating in the Commission on Water Resource Management's water audit program. Condition 4 requires providing FAA notice of construction and otherwise working with FAA to ensure there are no impacts to aviation. Condition 5 relates to providing notices to lessees regarding who are in proximity to the airport. Condition 6 deals with hazards to aircraft operations and requires continued work with DOTA and the FAA. Condition 7 relates to the highway improvements. Condition 8 is our commitment to avoid potential impacts to hoary bats. Condition 9 refers to the requirements to minimize the impact on seabirds. Condition 10 includes minimization measures designed to decrease the likelihood of spreading invasive species. And condition 11 details the infrastructure deadline. Conditions 12 through 19 are standard commission conditions. I won't run through those. They are stated, of course, in the draft DNO. The last two conditions that I'd like to cover, condition 20, relates to those commitments that Paloma Lanai made at the last hearing. The first is the commitment regarding the type of renewable energy intended for the 127-acre portion of the project. Former Commissioner Chang wanted to ensure that that representation or that commitment remains, that the project, that area of the project will be used only for PV and battery storage. And so we have incorporated that condition. Condition 21 relates to the discussion of a potential impact on ratepayers if the existing hotels are pulled from the grid. And as to that condition, we believe that we have captured the Commission's intent to ensure that there is no impact to ratepayers. Through the evidence that's been presented, through the draft decision and order, and through the conditions that we have incorporated, we believe that we've met all of the decision-making criteria, satisfied the concerns that were expressed by the Commission, and worked with both the Office of Planning and Sustainable Development and the county to incorporate a DNO that is faithful to the record and that adopts appropriate conditions. That concludes my presentation. I'm available for questions, of course, and we respectfully ask for your approval. Thank you.
Thank you, Mr. Chip Chase. Commissioners, any questions to the petitioner? Commissioner Atta?
Yeah. Could you? I just want one more for clarification. I just would like to know that Commissioner Chang's was concerned to how the ratepayers will pay. So what financial condition are we talking about?
Absolutely, Commissioner. So as to that, it's set out in condition 21, but I'll read it for the benefit of the Commission. It states, if an increase to ratepayers will result from the removal of the two hotels from the existing grid, petitioner will commit to either offset the increase or not remove the hotels from the grid.
Yeah, fine. Thanks.
Commissioners, any other questions? I just had one. The 87% of infrastructure within 10 years, I presume that assumes that the renewable energy project will be completed within that time frame. Is that correct?
That's correct, Commissioner.
Okay. That's a big part of it.
It is.
Yeah, okay. I don't have any additional, Commissioner Cabral.
Yeah, my question is on this promise or commitment to relieve the continue absorbing the electrical usage or to pay so that the residents aren't impacted by such a drop. Is there a better formula figured out on exactly how that's going to happen? That could get very confusing or controversial. Is it as it moves forward? I mean, are you basing it on what the consumption is now, but more people move in so they consume more, so you have to pay back less? I mean, has anybody worked out exactly how that's going to happen at what time and framework?
I'll turn any specifics over to Ms. Dancel for clarification or confirmation. But what the essence of the condition is intended to address is the potential that removing the hotels from the existing grid, so not directly related to the solar project, but removing them from the grid could impact ratepayers because now fewer number of users have to absorb a greater number of set or fixed costs. And we're able to address any such impact by either offsetting that cost for consumers, or if we aren't or we're unwilling to do that, we won't remove the hotels from the grid. So whichever way we approach it, the net impact to the community, to the other ratepayers, will be nothing. And Keiki Pua, if I missed anything or misstated anything, I invite you to correct it.
So that would be regardless of what, like, as of today, the residents are consuming so much and the hotels so much, okay? But if 5 or 10 years from now, the residents have grown and now they have a greater percentage, is it based on that percentage, or have the population shrunk and absorbing less? You're still gonna make that differential at whatever time frame you go off the grid?
So if we did go off the grid with the 2 hotels, the determination would be made at the time the hotels are taken off the grid, because that would be the point at which ratepayers may be impacted.
Okay, thank you very much.
You're welcome.
Let me add a question along those lines that might help clarify for everyone. At the hearing on that we had, either you or Mr. Matsumoto, might have been you, Ms. Dancel, indicated that you had ongoing, off and on negotiations, discussions, which are proprietary in nature with the Hawaiian Electric Company and Maui Electric. I would presume that this provision would be part of those continuing discussions as they might occur. Is that correct?
Aloha, Chair. This is Keiki Pua Dancel from PÖLAMA LANA. Yes, that is correct.
Ms. Dancel, I've been reminded by my second chair here, I have to swear you in before you could say anything. So do you swear that what you're about to say is the truth, and then you can say it again?
I do.
Thank you.
Aloha, Commissioners. Yes, that is correct. Those will be part of those discussions.
Yeah. So my read of that is that it will not be an individual matter. It would be a formula would be developed to the mutual interest of the electric company and PÖLAMA.
Thank you.
Yeah. Okay, any other questions? I have one question. Commissioner Higashi.
Just for clarification, stipulated condition number 11 and stipulated condition number 15 deals with 2 different aspects of the project, but both say that it'll be done, the infrastructure will be done within 10 years. Are you bifurcating the infrastructure, or are there common infrastructure that is required for the whole parcels? Do you need, essentially, do you need these 2 conditions, or is there a reason why there are, or just that? I'm just curious about that.
If you just, I'll take a moment to just read them to make sure I answer your question correctly.
You think they're redundant?
You know, I just wanted to know why.
So Commissioner, condition 11 is specific to the development of the proposed PV and battery storage project, which, as the chair mentioned, consumes a substantial portion of the anticipated land area. And so in discussions with OPSD and the county, has determined that a condition specific to the development of that infrastructure in that area would be appropriate. Condition 15 is the standard commission condition with respect to backbone infrastructure. And so that's a condition that's always imposed as part of the project. And so I do believe that for this case, in this matter, both conditions are appropriate and not in conflict.
And no, condition number 19 is our general conditions requiring that that you're going to develop this project within the parameters of, not, well, fully or partially release the conditions provided here into all portion petition of time in motion. Oh, that's not the one. The section that I was going to ask you about was the one that says that you're going to develop this in substantial compliance with the representations that you made. I think it's condition number 14.
14, Commissioner.
And so the statements that you made on behalf of your client regarding the rate payments and the timing of any compensation or decisions on that, on condition number 21, that would be a substantial, I believe would be a substantial representation to the commission.
No argument, Commissioner.
And in addition to that, I believe that you indicated one of, I forgot who indicated to one of my questions was that whether or not the cost of these proceedings or the cost of getting your developmental rights within this proceedings would be added to the cost of the lease to a third person for purposes of obtaining, well, for the purpose of the photovoltaic facility or the photovoltaic things. And you indicated that it does not, because the proposed lease rent is locked or made within the PUC determination, and that there will be no changes to that proposed lease amount.
Commissioner, if I may, I'll just turn it over to Ms. Dancel for confirmation.
I know it's just, I'm just working off my memory. That's why I'm sorry if it was so tough.
Aloha, Commissioner Ohigashi. So if I understand you correctly, you're asking if the lease rent will increase depending on the cost of these proceedings? Is that the question?
No.
Or? Okay.
My question was, there's a difference between getting developmental rights for land and having no development rights for land. Under the agricultural district, which is this in photovoltaic systems are permitted use and requires a special use permit. My question was, because you went through the urbanization of the land and from agriculture to urban and getting that right, would that cost increase in obtaining those developmental rights be transferred into the lease, or will it be treated like you would be getting a special use permit under agricultural purposes?
So we haven't fully negotiated right now with the, there is a selected developer and we haven't fully negotiated the lease costs. Our objective is to provide the most least costs to our customers on Lanai, our residents. And so we would be reasonable. So it wouldn't be what you would normally see of an ag. It wouldn't be a straight urban lease with all the developments, all those things rolled into the ag rate or the urban rate. It would be closer to ag, but not necessarily just an ag rate lease, because the ag rate lease would be different than the urban, but we wouldn't roll in all the costs. Our objective is to provide the lowest cost to our customers.
My recollection when I asked that question was there was an assurance that it would be under an agricultural type of lease. And but you can correct me if I'm wrong. I can look back on the record if I'm wrong.
I don't remember. I remember the discussion, Commissioner. I don't remember exactly the response. If I remember the discussion correctly, it dealt with the differential between what the cost would have been to pursue a conditional use permit versus pursuing the district boundary amendment. Would that differential be charged to the lessees? And I believe the answer was no. And so Ms. Dancel has confirmed that that's correct.
Okay.
Thank you, Mr. Chipchase and Ms. Dancel.
You're welcome, Chair.
To the County of Maui, Mr. Hopper, do you have any closing arguments you would like to make?
Just briefly, Chair. The County of Maui Department of Planning supports the request for district boundary amendment subject to the 21 conditions set forth in the stipulated decision and order. This is consistent with the position statement that the county's filed in this docket and noted in the position statement and throughout these proceedings that this is consistent with the designation in the Lanai Community Plan of light industrial. The county believes that this request meets the requirements of the district boundary amendment proceeding as far as the criteria for reclassification and has filed a position statement as aforementioned to that effect. We're available for questions, but at this stage would recommend that you grant the district boundary amendment as set forth in the stipulated decision and order. Thank you.
Thank you, Mr. Hopper. Commissioners, any questions for the County of Maui? Commissioner Okuda.
This is Gary Okuda. Thank you, Mr. Chair. Mr. Hopper, do you have any disagreement with the statements of law that Mr. Chip Chase went over during his presentation?
I think he essentially basically went over the criteria as set forth in both your rules and Hawaii revised statutes for the requirements for reclassification. So I don't have a disagreement that I can think of.
Thank you very much. No further questions, Mr. Chair.
Got two items. I just want to confirm that the slide presentation that you shared with us today will be made available to LUC staff for the record.
Yes, Chair.
Thank you. So when I updated the record, I noted the Office of Planning and Sustainable Development filed their response. I don't think I said that the County of Maui filed its response or that we had received it. And you just said that you did send in a written response?
Oh, not a written response. We let the petitioner know that after a very small change to the condition that we could agree to stipulate to the decision.
Now you're just verifying that.
Yeah, that was represented by petitioners in their filing. So they did seek that from us, and it was an accurate representation that we stipulated to this decision in order after a small change to the condition.
Fair enough. Thanks for clarification. Commissioners, anything further for the county? Thank you, Mr. Hopper. We'll proceed. Mr. Yee, OPSD, closing argument.
Good morning. This is a proposal for an industrial park, which is not a naturally popular kind of project, but it is nevertheless important for any island economy to locate a place where these industrial activities can occur in a singular area rather than being distributed throughout the island and potentially conflicting with other uses. So this particular industrial park is consistent with the county plans and for which there has been community outreach and without any significant community opposition. We are satisfied with that they have come up with a plan that will satisfy both the legal and discretionary choices to be made in approving it, and appreciate the gracious cooperation of the petitioner and county in coming to an agreement on a proposed DNO. The Office of Planning and Sustainable Development supports the project and supports the adoption of the proposed and second amended proposed DNO. I'm happy to answer any other questions.
Thank you, Mr. Yee. Commissioners, any questions for OPSD? Seeing none, I have none. Thank you. I just wanted to ask the parties, we did have a delay where we had to amend the dates. And I think that was triggered more by the delay in getting the transcripts out on a timely basis from our hearing, as opposed to any difficulties that you were having achieving a stipulated agreement. Will the parties comment on that?
That's correct, Chair. And I would also say that the timing in the sense of the holidays played a role in it as well.
Okay,
so I appreciate the parties' cooperation and the commission's consideration in extending those deadlines so that we could get the transcripts, finish the draft DNO, and work out the conditions.
And have a nice holiday.
That too.
Yeah. Yeah, fair enough.
If I could just note, it is a constant refrain from us. More time is better. But with that, I will leave it alone.
Okay, Mr. Hoppers,
think I agree with everything that was just said. So thank you.
Thank you. Okay, we're now going to give an opportunity for public testimony, second round, if anybody would like to afford the public to provide additional testimony. Please raise your hand if you are here, and you will be recognized. I don't see anyone, so Ms. Kwana, are you aware of anyone that is registered for public testimony at this time?
No, Mr. Chair.
Thank you. So we'll close the public testimony and proceed to formal deliberations. Before we take up any motion, the chair would like to confirm for the record that all commissioners and myself are prepared to participate in these proceedings. Commissioner Cabral, have you had a chance to review the recording of November 16th, 2022 meeting, and are you prepared to participate?
Yes.
Thank you. Commissioner Ogahi, are you prepared to participate?
Sure. Yes.
Commissioner Okuda,
Yes.
Commissioner Ata,
Yes.
Commissioner Kahele,
Yes, sure.
Commissioner Kamakea Ohelo,
Yes, sir.
and the chair is also prepared to proceed. The commission will now enter deliberations.
Mr. Chair.
And entertain a motion.
Mr. Chair.
Chair recognizes Commissioner Ohigashi.
Move to adopt the stipulated, what is it called? Stipulated proposed findings of fact, conclusions. Let me amend it to say, the second amended proposed findings of fact, conclusions of law, and decision and order submitted by the petitioner and stipulated by all parties.
Let me confirm with Mr. Orendecker, did you get that?
Yes, I did, Chair. The motion was to adopt the stipulated proposed findings of fact, conclusions of law, and decision in order as submitted by the petitioner and agreed to by the parties.
The second amended version of that, correct?
The second amended, yes, correct.
Okay, do I have a second to that motion? Second by Commissioner Kahele. So Commissioner Ohigashi, would you like to speak to your motion?
Yes, I commend the petitioner for complying with all the great requests that the commission had. In addition to that, I commend the petitioner for putting on a very good case like Mr. Chase always does. I do have some lingering concerns about the previous actions in this area. The granting of a special use permit for certain parcels of land that are now covered by this change, this urbanization of this particular parcels. And I do think that the county of Maui engaged in, or the previous applications engaged in sort of in that form of shopping, or, well, to put it bluntly, I do believe that the activities of the county of Maui seem to have made, and the previous petitioner seem to have skirted the 15-acre issues in regard to those areas. I understand that nobody can contemplate the future in this matter. However, it would appear that when we take a look at the evidence of the past dealings, that this type of action was trying to parcel things out. I'm glad that the county of Maui, since that time, has come in support of this particular petition and to try and do it rather than in a piecemeal fashion, to do it in a whole fashion. And I apologize for standing on my high horse for my positions on special use permits, but that's given my time on the commission. I think that I'd like to leave with that crusade on board, but I wholeheartedly support the motion.
Thank you, Commissioner. Commissioner Okuda, would you like to speak to your second? Or Commissioner Kahele? Excuse me. Thank you. Any other commissioners want to speak? Commissioner Cabral.
Thank you, Commissioner Cabral here. I want to just make it clear that the motion is definitely going to include that is subject to the original 21 conditions that were identified in the stipulated and amended proposal. And that also that we want to make sure that we clear this, our land use commission staff to be able to make modifications or procedural matters and standardization in that, so that this is clear moving forward to involve less problems in the future.
Do you also want to authorize me to sign it once we get to
I
that?
will authorize you to sign it once it's ready, yes.
So I will take that as a friendly amendment to make, to that it include all 21 conditions and authorizes the chair to sign once it's finalized. Do you agree to the friendly amendment, Mr. Commissioner Okuda? I mean, Commissioner Oikashi? Just for clarity.
I'm only hesitating because you called me Commissioner Kuda. I agree.
Was quite a slip. Yeah. Yeah. Speaking of whom, Commissioner Okuda.
Thank you, Mr. Chair. I'd like to just follow up on the comment by Commissioner Ohigashi calling or describing what he said about special permits as a crusade. Okay, I think his position is well taken. What this stipulated decision and order demonstrates is that compliance with the intent and the statute and the administrative rules does not have to be overly complicated or time consuming if you have competent counsel making a presentation. And I don't think, by recognizing Mr. Chip Chase's competent work here, we're showing any favoritism, because as you know, on a number of other cases, we have taken a different position, notwithstanding the fact he's filed an appeal. So we view his presentations on a case-by-case basis. But I think the record shows that, the competence, and it's not only of Mr. Chip Chase, it's Mr. Hopper, who always does a solid job, whether we agree or disagree with him, and with Mr. Yee. So, if good lawyering takes place, the statute can be complied with at a reasonable cost to the petitioners and the parties, because we do recognize administrative procedures add to costs, and if we can avoid unnecessary costs, we'd like to do that. So I don't necessarily believe that what Commissioner Ohigashi is stating, or what he described as his crusade, is really something that causes a lot of additional costs if we have competent counsel who frankly don't try to skirt the plain language of the law. And this case demonstrates how competent counsel really can move a good project forward. So I think we should recognize what has been done here, since many times we might look like we've taken a different, more critical approach. So for that reason, those reasons, and the fact that the record and the evidence clearly supports the application of the law, I will be voting in favor of the motion. Thank you, Mr. Chair.
Thank you, Commissioner Okuda. Any other commissioner wish to speak to the motion? I see none. I have a couple of comments. I also want to commend all the parties for their performance in this agenda item and in this petition. very well received by this commission and very efficient. I think this is as Mr. Yee said, this is a good way to go for the people of Lanai to concentrate an industrial park in a logical place for the benefit of the island and move it forward. Ultimately, I want to compliment PÖLAMA Lanai and Mr. Matsumoto is not here today, but has been participant in these proceedings up till now, and Ms. Dansel. Very professional, very understanding, and in particular, the way that you conducted and worked with this commission at the hearing itself to respond to Commissioner Chang's interests and to my personal interests and the conditions 20 and 21. Thank you very much. I will be supporting the motion as well. Mr. Arndaker, would you like to poll the commission, please?
Thank you, Chair. The motion is to adopt the second amended stipulated proposed findings of fact, conclusions of law, and decision in order as submitted by petitioner and agreed to by the parties, including all 21 conditions, and that the chair be authorized to sign the decision in order. Commissioner Ohigashi,
Yes.
Commissioner Kahele,
Yes.
Commissioner Atta,
Yes.
Commissioner Kamake Ohelo,
Aye.
Commissioner Okuda,
Yes.
Commissioner Cabral,
Yes.
Commissioner Yamane is excused. Chair Giovanni.
Aye.
Thank you, Chair. The motion passes with 7 affirmative votes.
Thank you very much and congratulations.
Thank you, Chair, and thank you, Commissioners. We really appreciate your time and the approval of this project.
Thank you. Do good work.
Thank you.
This concludes our hearing for today. The commission will recess.
Before you conclude, I just
Before I conclude, yes.
want to say nice to see Ms. Aoki here and Mr. Harper. You're looking good. You're losing weight. Happy New Year.
Thank you, Commissioner.
I'd like to say also that I really wish we were on Lanai. We've had lovely trips to Lanai, and so I wish that we were there for these hearings. So if we have to come back, if you come back, thank you very much, though.
Hopefully soon, one day we'll be there.
Yes.
Okay. Anybody else want to make a comment before we conclude? Seeing none, this concludes our hearing today. The commission will recess and resume training tomorrow at Kihei Community Center, 303 East Lipoa Street in Kihei, 96753. The meeting will start at 9:15 a.m. tomorrow morning. Thank you all so much.
Okay, thank you.
Get to bang this thing.
Yeah, there you go. Do your job.